Conflict resolution in the legal field, mediation and negotiation. Title: Conflict resolution in the legal field, mediation and negotiation. Introduction, 100 words. Conflict is an inevitable part of society, and the legal field is no exception. Disputes can arise in various legal contexts, and effective conflict resolution methods are essential for maintaining justice and harmony. Among the various techniques available, mediation and negotiation have proven to be invaluable tools. This article aims to explore the significance of mediation and negotiation in the legal field, their differences, advantages, and the role they play in resolving conflicts. Mediation, facilitating effective resolution, 400 words. Mediation is a non-adversarial process that focuses on facilitating communication and reaching a mutually acceptable agreement between conflicting parties. Mediators, who are neutral third parties, lead the parties through the discussions, aiming to identify common interests and address the underlying concerns that led to the conflict. One of the key advantages of mediation is its ability to preserve relationships. Unlike litigation, which is often adversarial, mediation encourages open and collaborative dialogue. By fostering effective communication, mediation empowers parties to exchange information, express their needs and concerns, and empathize with each other's perspectives. This collaborative approach often leads to creative and flexible solutions that satisfy the interests of both parties, ensuring a win-win outcome. Mediation can be particularly effective in the legal field for several reasons. First, it is confidential, providing the parties with a safe and private environment to discuss their issues openly. Secondly, mediation allows for a more efficient resolution, as it bypasses lengthy court processes. This not only saves valuable time and resources but also allows the parties to maintain control over the outcome. Moreover, mediation often results in agreements that are more likely to be adhered to voluntarily, as they are crafted by the parties themselves, leading to greater satisfaction and compliance. Negotiation, finding common ground, 400 words. Negotiation, another significant conflict resolution tool, involves discussions between the parties involved to overcome differences and find a mutually acceptable solution. Unlike mediation, negotiation may occur in an adversarial context, such as during contract negotiations or settlement discussions. Negotiation is primarily a bargaining process, where parties present their positions, interests, and preferred outcomes. Skilled negotiators engage in principled negotiation, focusing on the problem itself rather than personal attacks. This collaborative problem-solving approach helps preserve relationships throughout the process. Negotiation encourages parties to find common ground, brainstorm creative options, and ultimately reach an agreement that meets their shared interests. In the legal field, negotiation plays a vital role in resolving disputes before they escalate into time-consuming and costly litigation. Lawyers rely on negotiation to reach settlements, mitigate risks, and avoid the uncertainty of court proceedings. Negotiation allows parties to have greater control over the outcome and can often result in more satisfactory resolutions compared to court-imposed decisions. Mediation versus negotiation, understanding the differences, 300 words. While mediation and negotiation share similar principles, it is crucial to understand their key differences. Mediation involves the intervention of a neutral third party who facilitates discussions between the parties, while negotiation occurs directly between the parties without a mediator. Mediation places more emphasis on open communication, cooperative problem solving, and relationship preservation. In contrast, negotiation might include a broader range of tactics, such as persuasion, compromise, or even limited forms of competition. Negotiation, on the other hand, may result in compromises or concessions to reach an agreement. Mediation and negotiation are invaluable tools in the legal field for resolving conflicts and maintaining justice and harmony. Mediation, a non-adversarial process, focuses on facilitating communicate and reaching a mutually acceptable agreement between conflicting parties. Mediators, as neutral third parties, guide the discussions, aiming to identify common interests and address underlying concerns. Mediation preserves relationships by encouraging open and collaborative dialogue, leading to flexible solutions that satisfy the interests of both parties. It is confidential, efficient, and produces agreements that are more likely to be adhered to voluntarily. Negotiation, on the other hand, involves discussions between the parties to find a mutually acceptable solution. Parties present their positions, interests, and preferred outcomes. It is primarily a bargaining process, but skilled negotiators engage in principled negotiation to preserve relationships. Negotiation plays a vital role in resolving disputes in the legal field before they escalate to litigation. Lawyers rely on negotiation to reach settlements, mitigate risks, and have greater control over the outcome. While mediation and negotiation share similar principles, it is important to understand their differences. Mediation involves a neutral third party facilitating discussions, while negotiation occurs directly between the parties. Mediation focuses on open communication, cooperative problem solving, and relationship preservation. Negotiation includes a broader range of tactics and may involve compromise or limited competition. Conflict resolution is an essential process in the legal field, and two effective methods are mediation and negotiation. Mediation is a non-adversarial process that focuses on facilitating communicate and reaching a mutually acceptable agreement. Mediators guide the parties through discussions, encouraging open dialogue and collaboration. Mediation preserves relationships, is confidential, efficient, and produces voluntary agreements. Negotiation involves discussions between parties to find a mutually acceptable solution. It is primarily a bargaining process, where parties present their positions and interests. Skilled negotiators use principled negotiation to preserve relationships and find common ground.